Order, order. Welcome to today's session of the Business and Trade Committee as we continue our investigations into securing justice and redress for the sub-postmasters who were victims of one of the worst scandals in British justice in our history. I'm very grateful for David and Glenys Eaton, who are joining us for our first panel today. Welcome to the committee, David and Glenys. And if I may, I would just like to start and say how sorry the committee is for the experience that you went through, and how grateful we are as a committee for you, after all of this time and for everything that you've been through, having the courage and strength to step forward and give testimony to the committee today. We very much hope that the evidence that you give us today will help us as a committee pursue justice on behalf of everybody else who has not yet had redress. David, could I start with you, please? Could you just give us, just very briefly, give us an overview of how your conviction was quashed? Just tell us, after the legislation was passed almost 2 years ago, what happened? How did you find out that your conviction had been quashed, and what was the process that you went through?
Basically, I received a letter on the 1st of the 10th, 2024.
Yeah.
And it was just a letter saying that my conviction had been squashed. And with it was a list of solicitors who could help me. I registered online myself on the 7th. And on the 15th, Hill & Co, I engaged them on my behalf. When I spoke to Hill & Co on the 15th, I mentioned my wife, who was jointly accused, and they had no knowledge of Glenn at all. So with that, Hill & Co made inquiries to the justice system to find out what was going on. They sent. And this was in the 10th of 2024. It was 4 months before my wife got a reply to tell her conviction had not been squashed.
I see. And so you had a letter quite quickly after the Act was passed about your conviction. Yes. And then could you tell us, how quickly did the government then pay the redress payment to you? Was that quite quickly?
It was on the 3rd of 225, sorry. 2 months. Which was 4 months after. 4 months. What I couldn't understand, it was only the first part of the payment. I couldn't understand why, if they were going to pay the redress, why wasn't it all paid in one sum?
Yeah.
No, just I think it was 200,000, and then wait and see then. So why wasn't the whole amount paid at the same time?
Yeah.
And it didn't make sense.
And was the rest of the payment ever paid?
Oh, yes, it was paid, yes. I mean, that came on the 27th of the 2nd.
I see. Okay, so a little bit after.
Yes. Yes.
Okay. Well, let's get into the situation that Glenys went through. Sarah Edwards.
So we're just interested in understanding more about the time frame and the timeline that you went through. So when you applied to the Horizon Convictions Redress Scheme, so we've heard that obviously, Mr. Eaton, it took you 4 months. Was that something that you were expecting to take as long? And what happened to your wife and her experience of applying to the scheme?
Our solicitor applied on the 15th of the 10th when I contacted him originally. And it was, let me see now.
The 14th of February.
14th of February the following year, that my wife got a letter saying that her conviction was not squashed. She did not meet the requirements.
So that's like a year that you were waiting.
Now, yeah.
Yeah.
Now, the issue was that we were convicted on the same date, joint charges. We went to the same court, we appeared before the same judge, and we were sentenced on the same day. We had the same set of solicitors and barristers, yet my wife, according to the post office and the Ministry of Justice, did not qualify. Now, what they based their assessment on was that the post office had said that my wife was not employed with them on the April before the offences, and that there was no record of income tax. Now, to be clear about this, we were self-employed. We purchased the post office. We owned the post office. We managed it jointly. We weren't employed directly by the post office. We were subcontracted. So how they can come up with that issue, I do not know. But for over 12 months, no matter what was said to them, and I wrote twice on 2 occasions myself personally, Co, if it hadn't been for them, we would have been lost. And I would say other people in the same situation are struggling now. They're not heard, they will not be notified, and not believed. I mean, what they did basically was the Ministry of Justice replaced the post office, and they took over the way they treated us.
So they hadn't understood your actual position as not being an employee. They hadn't fully understood that and taken that into account, is what I think you're saying. Is that
basically they should have done, because obviously we owned the post office.
Exactly.
The evidence was there.
But they wouldn't look into it.
They wouldn't look into it. What transpired and was reported to our solicitors, Howe & Co., was that they only investigated my side of the case into the court, not my wife's.
Mm.
Yeah.
They took it on just the basis that the post office said that she wasn't employed by them.
Okay, thank you.
And according to her, on the date of the offences, she robbed somewhere else. According to that, it wasn't the post office.
Yeah. Charlie Maynard.
Really? No,
No.
wasn't me.
It was.
Oh, sorry. Okay, a little weird. Hadn't got there yet. Thank you. So Glenys, when were you told your conviction was considered eligible to be quashed under the Act? Finally.
Oh, that was only weeks ago, literally.
Wow.
It got to a point where we had, we knew that we were in the right, and Howe & Co were fighting every corner they could for us. And it came to a point where they said we need to go to a judicial review. So we were asked to employ a barrister who would fight our corner.
Let's pay $5,000.
We had to pay over $5,000 for his services, but we knew we were in the right, and the only way we were going to get justice was to fight on, which is what Albert, our solicitor, was determined to help us to do. And as soon as they realised that we were going to a judicial review, and
In 3 days.
they immediately turned tail and said, "We have reviewed your evidence," which the barrister submitted evidence
22 pages.
identical to what it had been submitted before. He hadn't changed a thing. But according to them, they had new evidence in the past, and they were going to overturn my sentence. And it was all done literally days, which made me very angry, because it had been all that time with us trying to tell them to review it, look at it closely, look at what evidence had been presented. But all they did was take note of what the post office had said and disregarded anything that we'd said.
We were liars.
It was only officialdom of the barrister fighting our corner that actually got some movement on the case.
And during this process, did you have a named person that you were able to talk to and communicate with, or this was all by letter or by email, or how did this work practically?
Albert, our solicitor, was amazing. We contacted him on WhatsApp and on the phone, and we did do a Zoom meeting with him and David Enright from the House and co. We were kept in the loop all the way, and they were absolutely brilliant. They really were so helpful and so determined to see it through. What I hadn't been to them, we wouldn't have gone anywhere.
What I would like to add to that is that I wrote to the Ministry of Justice twice, and I sent them 8 questions for them to answer. They never answered one question. The second time I wrote again, asked them to answer it again, and they just came back with an email which was a sentence, a paragraph long, saying that there was no evidence to support it. And that's how they treated us. No matter what we said, they didn't want to know.
Well, I mean, this isn't a question, this is a statement, but well done for challenging it and for keeping at it, but you really shouldn't have had to.
No, absolutely not. Absolutely. The evidence was there from the very beginning. I mean, it was in the papers. It was reported in the papers at our trial. And so they had all the evidence that it was a joint venture. But, you know, it was, but there was a turnaround and said that my wife must have committed an offence somewhere else on that particular date. It was offensive and just unbelievable. I mean, for 12 months, they kept my wife more upset. And I mean, I can understand why people commit suicide, very much so.
Fair enough.
It was fortunate we were able to support each other. And there must be people out there now that do not know that they can address these issues. They're just fogged off, being told that, you know, because Harlanco could have charged us from the beginning when my wife's case was dismissed. They could have charged us to act on our behalf, but they didn't. They took it on themselves and they followed it. They were right.
And Glenys, can I just ask, what was the emotional impact on you of going through this roller coaster once again after everything that you've been through?
Pretty horrible.
Could you just come slightly closer to the microphone? It's just a bit hard to hear you, sorry.
The time in prison was absolutely horrible. And it was a time then when we got on with our life and we'd moved on and we'd made a new life in a new area. We settled down and forgotten about it. And of course, bringing it all back up again, it's been not been nice and it's not comfortable. Some of the time you feel very irritated, very angry, the way you've been treated, because we're not dishonest people and we try and live an ordinary good life. We've gone on with our lives and we've built back up what we'd lost. And we were happy and breezing along. And then this letter came out of the blue saying Dave's been sentence overturned. And it was, wow, how did they know where we were? We moved completely from the area we'd lived in before, 100 miles away. So there was no way anyone would have known where we were, we thought. Out of the blue. And of course, it all brought it back to the front of our minds again and think, wow, this is brilliant. We're going to get some redress from the horrible time we went through. And it's been constantly on our minds. And obviously with all of the letters and the toing and throwing of the solicitors all the time, it hasn't been allowed to settle back down again. It's been a relief when Dave's money was paid, and an even bigger relief to be told mine will be paid. And it feels now as if maybe we can get back on with life again and forget about the post office. But I do feel sorry for so many other people who are in the same boat that we were in, who've got no one to fight their corner. We do hope that maybe this will get people moving and be able to get some redress from this horrible time for everyone.
Yeah, just add to that. When just before we took out the thought of a judicial review, after our MP
Yeah.
And she passed it on to one of her staff, who passed it on to the MP, who I understand was responsible for the Ministry of Justice, who came back after a week or so and said, oh, he's been in touch with the Ministry of Justice and there's no reason for the change of decision. And that was the end of that little corner.
Ordinary.
That's how, again, they just weren't interested.
Another dead end. Okay, Dan Aldridge.
Absolutely.
Yeah.
David Glennis, thank you so much for what you are doing on behalf of all of us who have constituents who will have been affected by this. So thank you for what you're doing. Glennis, what would have happened to you if David hadn't been told that his conviction had been quashed? What do you think you'd be doing now?
We would have been carrying on as we were in our old life, and nothing would have changed because we weren't even aware that there was this redress system, and as far as we knew, it was all in the past. We'd finished that side of things with the post office, and we'd moved on. Admittedly, watching the program of Mr. Bates and the post office, we sat there enthralled and thought, God, that's exactly what we went through, and those poor people, and how many of them. We never realised. We thought we were
told we
the
were the
one-off,
ones,
because you're told when you put a complaint in, oh, it's not happening to anyone else, it's going to be you.
That's right.
And then to find out how many hundreds of other people have been so badly affected by it just made you angry. But nothing you can do. You've just got to fight your own corner and hope you win, which is what we've hopefully done.
Yeah.
Thank you.
Okay, thank you very much indeed. It's quite a bad line, so I'm going to just draw this panel to a close. But David Glennis, thank you so much for having the strength and the courage to give us evidence today. It's hugely appreciated. Your evidence is on the record, and it will form part of the report that this committee publishes in the aftermath of these hearings, with recommendations to ministers for the changes that they need to make, so that we can be sure that nobody else has to go through the appalling experience that you have gone through. So thank you very much indeed for giving your evidence to the Business and Trade Committee this afternoon. That concludes this panel. Order, order. Order, order. Welcome to this second panel of the Business Trade Committee's hearings into justice for the sub-postmasters. Thank you very much indeed to Neil Hudgell, David Enright and Kieran O'Rourke for joining us again. Thank you for the extraordinary work that you have been doing on behalf of so many victims. Neil, if I may, I'm going to start with the experience that we have just heard about. Could you just give us a sense of whether this is a problem that you've come across elsewhere? What's been the experience of your clients going through the Horizon conviction scheme?
Yeah, I think to give balance, Chair, in the HCRS, once the cases reach a point of qualification to be quashed and they enter the compensation process, it's relatively fit for purpose and fairly running. So I think that's a positive. The difficulty, and the case that you've just heard is not unrepresentative of quite a few, is reaching that point. And there are a couple of issues here, and you can see what those issues are by just looking at the statistics that sit on the government website. So there's roughly 1,000 potential convictions that can be quashed. There's 600 at the moment that I would describe as quashed, of which 570 have had letters and are going through the compensation process. There's 30 that are untraceable, so people have had convictions quashed, the 30 that haven't yet been found. You then have, and this is essentially the nub of the issue that involves these good people here and others, is still in the system there's 175 cases, so almost 20%, where there has been a request for further information.
Yeah.
And it's those where people are being sort of stymied in getting forward and having their convictions quashed, because from our experience, we have had about 40 at one stage or another have had a request for further information. And there seems to be a disconnect between the MOJ and the Post Office in relation to provision of information. The onus has been put on us and our clients to provide it. And I have some examples of that. And there's been instances where it's taken 14 months from a letter for requesting...
14 months?
A letter requesting information to then have the conviction overturned. And it starts with things like people's names being spelt wrongly on their letters. People's told that they don't have a conviction when they have a conviction, and we're obliged to provide evidence of that.
You're being asked to provide the evidence?
Yeah, we're being asked to provide evidence of that. And other things around clients. There are 5 qualifying criteria, so to clients being employed within the Post Office and doing Post Office related business. Those fairly simple qualifying criteria are being batted backwards and forwards between the MOJ and the Post Office, and in many instances are coming to us to be resolved. And it's indicative of a wider issue around incomplete disclosure that still continues to pollute across the whole.
So you're saying that the Post Office is not, I mean, there's a problem with speed, but you're saying that the Post Office is not supplying the information that is needed for the MOJ to make judgments?
I think there's an element of that going on. I mean, we're only looking at it from one side, and what we're seeing is a demand on us to fill the gaps that we think ought to be able to be capable of being filled between the two organisations.
Let's just get a full spread of the issues. David Enright, what's been your experience working for your clients on this scheme in particular?
Exactly. You've heard from David and Glenys. The sound was bad, and I think it's important because there are questions from Mr. Maynard that didn't quite come across. They founded their post office in 2000. Horizon was introduced in 2001. They immediately started experiencing massive shortfalls. They were arrested in December 2001 together. You had a husband and wife working in the same post office they run, arrested for the same offence, prosecuted for the same offence, convicted for the same offence, both went to prison for 6 months. And that's 24 years ago. Mr. Eaton wakes up one day with a letter on the doorstep saying that his conviction has been quashed. He and Mrs. Eaton sit down together at the breakfast table, astonished at this news. They contact us, in fact my partner Albert Harwood, and in that conversation it brings up the fact that his wife had an identical position to himself. So we said, well, that's unusual. So contact the MOJ and DBT about this, and you've heard about the delay in the response. And they come back and she's not eligible. And then we engaged in a titanic battle over 6 to 8 months of correspondence, all by the way, pro bono, to try to get them to understand that they have a husband and wife in an identical situation. You've quashed the conviction of the husband, but not the wife. And we had to take the step of issuing judicial review proceedings. And unfortunately, and quite naturally, we had to instruct counsel on that, who had to be paid. So the Eatons had to dig into the compensation that Mr. Eaton had received to pay to fight. When we issued that judicial review...
David, so if Mr. Eaton had not received that settlement, then presumably Mrs. Eaton wouldn't have had the firepower or the funds to take the case forward. Is that the case?
What this case... Well, absolutely. But what this case crystallises is the two key issues. And the issue is that Parliament, in this unprecedented act, stated its will, that they wanted all wrongful convictions quashed. Now, the Department of Business and the Ministry of Justice do not know what the number is. They do not know what the shape of the problem is. That is a fundamental issue. You cannot solve a problem that you do not know the shape of. So they need to come to you and they need to say to you, this is the number of the potential beneficiaries act that there are, and this is why we think that that's a robust number. Because, as Mrs. Eaton demonstrates, they do not have the right
This is
number
what worries
and they're
me. So
missing.
the Ministry of Justice says that there's 1,002 individuals who, in their words, appear to qualify for the Act. But there are then 205 individuals listed who, in their words, do not appear to meet some of the conditions, and another 25 who don't appear to meet other conditions. So you've got 230 individuals there who the MOJ has judged do not meet the criteria that they've set out under the Act. But then in the letter from the Minister that we received before Christmas, in paragraph 5, it says that they've decided not to write to those individuals because they may not be exonerated. This sounds like a recipe for many more of the cases we've just heard about.
How many Mrs. Eatons are there? Because what happens, Chair, is that someone at the MOJ and DBT sit down and consider the conviction of Mr. Byrne. You have no idea that's happening. None. So if on a good day, someone says, well, it's on the borderline, give it to him. On another day, got up on the wrong side of the bed, no, that's not enough for me. You never know that you were in the mix. You never had the opportunity for someone to write to you, Mr. Byrne, and say, we've considered your case, we think you meet criteria 1 and 2, but not criteria 3 and 4, to give you the opportunity to say, fair enough, or...
You've got a consideration in secret, a decision that is made in error, and an appeal that is frankly in the lap of the gods.
No oversight. None. No oversight.
How many more cases like Mrs. Eatons do you think are out there? Do you think there are other cases like Mrs. Eatons out there?
Well, sir, Mr. O'Rourke, Mr. Hudgell and I have sat in meetings with the Ministry of Justice and DBT from the inception of this Act, indeed before the Act, and we highlighted these precise issues again and again and again in those meetings. We provided solutions to these problems, to identifying where the victims were. Mr. Hudgell has talked about the missing victims. There's significant numbers of people. We provided them with potential solutions to that problem. But the key thing is we said to them, you do not know the figure. And you are conducting a closed-door eligibility process to which the victim has absolutely no sight at all.
Is it your view then, Mr. Enright, that there are other missing victims out there?
I am, to be certain it would be wrong, but I am certain that there are many Mr. and Mrs. Eatons out there. Because she cannot be a freak example. Every post office in the country effectively is run by mum and dad or mother and daughter or wherever it is. So when one goes down, the other has gone down. The fundamental problem is that DBT must satisfy this committee is what is the number who are in the mix for consideration. Secondly, what is the process you are using to assess eligibility? What standard of proof are you using? What evidence are you weighing? What's the source of that evidence? And are you or are you not communicating that to say that you are conducting that assessment to the potential beneficiary so that they can add into that and say, well, I actually have evidence. As Mr. Hudgell has said, you say I didn't have a conviction and Mr. Hudgell comes forward, well, there's the conviction.
Yeah. Mr. O'Rourke, do you want to just round out the picture for us and tell us what your experience and perspective has been?
Well, I would be repeating what my colleagues have said. I think the issue is we do not know how many Mrs. Eatons there are out there. That is an extreme worry because Parliament intended that the victims of this scandal would have their convictions overturned. And it seems that it may well be individual decision makers or groups of them within the Ministry of Justice, DBT, who knows if Post Office have some involvement in this, are making these decisions, and the individuals whose cases may be in play have no access to information, but also to legal advice which would allow them to become involved in the scheme. Because just saying, oh, we'll write to them and let them know will not be sufficient. And I'm not trying to make a case for lawyers, but we've just made a case for lawyers.
In this case, we've got a exactly. telling us they're not writing. They're refusing to write, in fact.
But without, for those who are refused or rejected, they will need to have some initial ability to get advice about that. I think it would be very difficult for an individual who now may well be very elderly, and obviously if they've been to prison, they may have some psychiatric or mental health issues, to just be able to write back and say, no, you're wrong. Yeah. I don't think that will tip the balance in their favour. So I think there has been an equality of arms, Chair.
Yeah. Sorry, Edwards.
Thank you, Chair. I was just wondering, just coming back on some of the figures that we'd heard, you know, where we've got 1,000 convictions that were being considered and 611 sort of eligible, and so we've got about like a 60-40 here. I mean, it's an absurdly high figure, isn't it? Really, of potential wrongdoing or fraud. And I was just wondering whether there'd been any thoughts around, well, what's the reasonable figure? And are we not on the basis going here that the presumption is that they are innocent, again, because most of these convictions don't hold water as far as we're concerned based on this atrocious software. So I was wondering what the thoughts were around just the fact that we're still having a debate around quite ludicrously high figures of so-called fraud in our postal system by, as we've heard, ordinary people running a local business.
Mr. Hutchell, do you want to start?
It's a very good question. I think from my perspective, and again, we can't make any assumptions, but these are highly traumatised and damaged people. I had an equivalent, Mrs. Eaton, come to me before Christmas. And again, restating the numbers, we've got 150 people have got letters out there where they're awaiting information. Now, they've not knocked on my door, and I don't think many have knocked on your door. So there are 150 people that have letters from the MOJ saying, you may qualify, you may not, please provide further information, who are unable to deal with those letters. That's 150. And there are another 25 that they've not been written to because there's no addresses for. Yeah. So there's a real significant cohort of people at the moment for which justice is denied.
Does that not still imply, though, that the assumption is that they were convicted on the basis of software that they still believe potentially to work? Is that not the sort of default that you can read into on the basis of that correspondence? It's pretty odd, isn't it, to be saying, well, you need to give us some more information.
Well, I guess what's said ultimately is it's public money. We've got to go through the right hoops to make sure that you satisfy the qualifying criteria. As I said earlier, I think the qualifying criteria are relatively light, and the Post Office and or Ministry of Justice between themselves should have enough access to tell if somebody had arisen in a particular time period and worked in a post office and has particular offences. It really ought to be as simple as that, and to have to wait 15 months for us to prove something where we've got clients that are highly traumatised from the events of 20 years that have not a scrap of paper is unfair in the extreme.
Thank you.
Yeah. If I could just add, I've identified the key problems, the two big problems, but underneath those there are other things. So, for example, and we heard evidence about this when you last looked at this, that there's a significant number of people whom the Ministry of Justice and DBT have written to say that your conviction has been quashed and you're eligible for compensation. And they have replied to say, never contact me again. Never speak to me again. Can you imagine what would prevent a person from accepting £600,000 in compensation? And we have urged the Ministry of Justice and DBT to find more creative ways of engaging with these people who they have already quashed the convictions of, who are effectively refusing compensation. We can imagine the reasons why, the barriers, those people, what they feel. And we have said to them that, I'm sorry, it's not good enough to say that we respect their decision, respect their privacy. To find more creative ways to get organisations such as the Restorative Justice Council or some other agency to contact these people and to say, look, just to be clear here, your conviction has been quashed, it was never your fault, and you are entitled to compensation. No one will ask you awkward questions, and to bring these people home as well. So that's another statistic. When we met with the Ministry of Justice early on, we were looking into the eligibility, and we eked out of them the statistics about the numbers of people they were finding as ineligible. We could only get them from Scotland and Northern Ireland. both of whom said it was about 20% of the people they were assessing at that time were being deemed ineligible. They never knew they were ineligible. We didn't get the figure for England and Wales, but I'm sure we'll be able to work it out. But that's the thing. Within that 20%, which is hundreds, there will be other Mrs. Eatons. That's undoubted. Okay. And one person sweltering for decades under a wrongful conviction, like Mrs. Eaton was for 24 years, is one person too many.
Yes. And Aldrich.
Thank you, David. You talked about warning authorities from the inception on this, and I just wondered, what, in your opinion, why those warnings weren't listened to by authorities? What do you think?
Sorry, I just missed the very beginning of your question, sir.
So you talked about warning people from the inception that this was an issue, and I'm just wondering what, in your opinion, why those warnings weren't listened to by authorities.
It's hard to understand because, to be honest with you, the meetings that we had, they were collegiate meetings where we sat like this with representatives of Ministry of Justice, Post Office and DBT, and we had a back and forth, but a collegiate back and forth where we said, well, this is the problem and these are the solutions, and we just couldn't get our head around why they were not seizing the solutions we're giving or recognising the problem that we were identifying for them, which is right there before them. And so we struggle to understand. Have you anything to add to that, Mr. Wood?
No, not particularly. Obviously, I think they know better than us on this.
Whenabouts were these meetings happening? Because I worked for the Chartered Institute for IT before this, and we were banging on the doors of government before the Mr. Bates debate, the Mr. Bates TV programme. And then all of a sudden, a drama came out and captured the public's attention, and then things started to move. Massively frustrating for those of us who were working in
design. It goes back to April 2023. Because at that time, Post Office was conducting an internal review of its own of people they had convicted to see, are there someone there that we should suggest go to the CCRC? And we wrote to them then saying that you can't have a closed door process where the perpetrator is deciding behind closed doors. So that was long before the Act. And in the run-up to the Act and in the immediate aftermath of the Act and regularly thereafter, we met with DBT and MOJ making these points again and again and again. In writing as well as in person.
Has this problem now been fixed?
No.
So even after the case that we've heard about today, the problem in the processes persists?
Well, I spoke to Professor Moorhead, who you know, a highly respected member of the advisory board, about 6 weeks ago, and again raised the Eatons case with him and what it exemplified. And he said, well, we told MOJ, we told DBT that they must write to people who they are deeming ineligible. Has that not happened? So there's been some suggestion now that that may have begun recently. But what about all the people over the last...
I have a letter from the Ministry of Justice dated the 16th of December that says, quotes, we believe that it would be insensitive to write to these individuals as we believe they would know their convictions are not in scope of the Act.
Which is it's madness.
Well, the problem with that, of course, is that, as we've already established, that those letters can often be in error. You know, we've had letters that said you're not in scope. Basic inquiries and investigations, they are in scope.
Just help us understand why the MOJ is not able to assemble the information they need in order to make judgments under these criteria.
I think there might be
Are they asking the wrong questions? Is there a gap in the data? I mean, why? In Mrs. Eaton's case, obviously, everything did turn out to be on the record, but somehow it wasn't assembled like a jigsaw puzzle to come to the right decision.
The position of Mrs. Eaton's case never changed. There was no new evidence at any stage, even though they said at the time when we issued the judicial review that we were conceding this case on the basis of new evidence. There was no evidence, new evidence. Mr. Howard wrote to them and said, where's the new evidence? There was none. I think it could be a cultural thing. The Ministry of Justice is a criminal justice system. Our criminal justice system is based on very high standards of proof, reliance on the courts, reliance on the appeals process, and it's extremely difficult to overturn a conviction through that. So you'll have a mindset that, you know, there has to be very significant evidence to overturn a conviction, and that'd be something in the back of your mind. But that's not what Parliament intended. Parliament was very clear that this is such a difficult issue, a Gordian knot, a web woven by Post Office with the help of Fujitsu. We must cut through it. And so they did cut through it, and they asked DBT and MOJ to fulfil the will of Parliament, and it is not being done.
Mr. O'Rourke, did you want to add to that?
Yes, I think there is a danger here that in my experience and in our experience of the meetings, it's very clear at senior director levels within DBT and within the MOJ and at ministerial level, everybody wants to get this right. So I don't think it's a case of there are nefarious characters trying to block people from having their convictions overturned. The problem is the system. It's the system, and it's always the system. It's a question of resource. It is difficult. You're going back to, we find it difficult as lawyers. You're going back through things that are decades old, and I'm not trying to make excuses for them, but the reality is there is a genuine willingness to get this right. We do have a collegiate approach, but sometimes they don't listen to everything that we say, and they make their own decisions. And I think it's individual caseworkers who may be working on a matter are making decisions that in the end are about whether someone was or was not guilty. And that needs some oversight. It needs some import for the person who is at risk of having their conviction not quashed, some ability for them to make an argument with some resources to make that argument. And that would make the system fairer, because at the moment that aspect is not working. But to say that this aspect is the nature of the whole system would be wrong, because obviously there are clients of ours who have had their convictions quashed and are happy with their compensation packages.
That is why we have an appeal system in law generally, because to err is human, but to correct is divine.
Yeah.
There's no appeal system here.
Yeah.
Exactly. Okay. Right, let me just summarise this. So you've basically said to us that you think that there are missing victims out there who have not been exonerated. There isn't an appeal system in place at the moment, and there needs to be one, and therefore people who have been reviewed and deemed not eligible under the Act should be written to, and they should be supplied with advice so that they can make representations that are well informed in order to ensure that justice is done. Is that a fair summary?
Correct.
Yeah.
Okay. Mr. Madders, let's move on to the Horizon Shortfall Scheme.
Thank you. Good afternoon, everyone. So, in terms of the Horizon Shortfall Scheme, obviously your evidence previously has been about delays in providing information and value of offers being made in particular. Do you feel that in the round things have got better since you last gave evidence to the committee?
There's a lot in that question.
Yeah, of course.
I think that what I would say is I think the HSS is broken, and I don't think there's much you can do about that. Let's just recap. Let's just rewind to the beginning. It was set up in the very early days with an expectation of small numbers of claims, and so claims were submitted without the benefit of legal advice, but they were submitted in their volume, and the scheme could never cope with it. So, and the scheme has never changed, so it's still churning out ridiculously low offers. And the way where we are at the moment is that we're waiting for offers to be churned out in the HSS so we can then transfer them to the new HSSA. Because in better news, albeit it's very much early days, what's happening in the HSSA is broadly quite positive. Offers are vastly improved, and I'll give you a couple of examples of that, and they're coming out way quicker. So DBT, and again, to take what Kieran said, a lot of collegiate dialogue to establish a new scheme that is more fit for purpose and that runs quicker. So I think the real nub of the issue is with the HSS, because there's still a considerable number of cases to be assessed in the HSS.
Can I just sort of come back to you on that point in terms of the appeal offers being much more satisfactory? A judicial analogy would be that once an appeal court has made a decision, the lower court, the HSS, would be responding to that and adjusting its offers accordingly. Is there any sign of that so far?
No, they proceed on a very rigid basis, and the offers that are still being produced are wholly inadequate.
They make no reference at all to appeals.
No,
Right.
no, because what they're saying is they have a process that needs to remain consistent from beginning to end, and that's why we only see that now as a vehicle to get from A to B. Because but even the offers that still wait to be made in the HSS, on average, if they're going to be a fully pleaded case, are taking 450 days, and this is from the government's website. If they're those clients that want to go down the 75k fixed route, it's still taking 136 days just to get offers out. So if you've got a fully pleaded case that's going to be inadequate, you're going to wait the best part of a year and a half at the minute to get an offer that we then have to transfer into the HSSA.
Just so that you're telling your clients before you even start, this is going to take over a year, and you're going to have to appeal almost certainly.
Management of expectation.
Yeah.
Day one is, I'm sorry to tell you this, but you're going to have to wait while you get an offer. When you get an offer, you're going to hit the roof. You're going to be, and then you're going to hit the floor with your anxiety and your depression. Yeah. We're going to have to get you back up, and we're going to say we will sort you out eventually, but it's going to take another 2 or 3 years from now.
I just want to make sure we've got an answer to Mr. Madder's question, though, about the scale of the offers, because the evidence you've supplied the committee shows that the median is a 5-fold increase in the value of the awards made once they've come out of the appeal system, as opposed to the HSS scheme. That is a huge increase in the appeal numbers and the values that are awarded through appeal. That tells us surely that something is fundamentally broken about the offers being tabled under the HSS scheme.
Yeah, there's a few things wrong. Firstly, there's no legal advice, so people don't know what to claim for. Secondly, the HSS doesn't account for a proper loss of earnings claim or for partnership losses. Just doesn't allow it. So, I'll give you a tangible example, and I know that statistics can tell you anything, but poor chap that started in the HSS had an offer of 20,000. He was one phone call away from taking that offer. He rang us, he could have rang David, he could have rang any other firm on the panel, and they would have no doubt done the same thing. He got that offer now, sits at 854,000, and it's not enough. Other examples, similar, 400,000 to 1.4 million, 118,000 to 1.15 million. And I don't say that the people that run the HSS, they've got one hand tied behind the back. They're all very competent people that know what they're doing. But if you're not presented with the right evidence to make proper offers in the first place, then you're gonna struggle. So but lessons are being learned. So the key for me is, how do we get that rump of cases that's still to be determined in the HSS across to the new appeals process and into that machine where they have their own obligations to process them and produce offers within 40 working days as opposed to 460 days.
I think you're pretty clear about the value of the offers being made. Are they consistent across the board, or do you find, depending on who's sort of dealing with it at the other end, that they can vary quite widely?
There's greater consistency.
Okay.
I won't say there's total consistency because that depends on different people on different days. And when you're dealing with some sort of unliquidated heads of loss, opinions can vary within a range, but it's less of an issue.
Okay. What have the other witnesses have got anything to add to?
Yeah, thank you. I would like to add to that. Our view at Howe & Co.'s is similar, if not identical, to Neil's. Obviously, the HSS appeal scheme is quite new, so cases that were in the HSS have started to move through the appeals process. We have similar cases where, for example, one of our clients on the HSS was given a good offer of £467,000, but within the HSS appeals scheme with DBT, we were able to increase that to 1.8 million. Another of our clients was offered 66,000. Eventually, we were able to get that in the appeals scheme raised to 382,000. So it's not just Neil's firm that's doing good things. It's clearly the fact that the scheme is run by DBT, the appeals scheme is run by DBT, and their lawyers are familiar with the issues. And I have to say they are more generous. They are more willing to give the benefit of the doubt than the HSS panel, who have no information. They don't have the expert reports, they don't have the medical reports, expert medical reports. I have asked at several meetings, and we have asked this at several meetings, because we still do have those collegiate meetings with DBT, could we please just skip to the appeals process? Why do we need to go through the HSS panel process if a client wants to just get a forensic accountant's report and a medical report and present a proper case to a body that will determine it fairly, which is DBT's side?
And can I just check with you, Dr. Hudgell, your viewers as well, that the more complex cases should just go straight to the appeal of DBT?
Very definitely.
Yep. Okay.
Sorry, just to follow up on that, so what answer did you get back when you asked that question?
I think the answer we get back is it hasn't happened, I have to say. So we haven't got the positive answer we want, but I think it's difficult because that scheme is in existence, and it's almost like we can't do it because it's already in existence and these cases are in there. I just think that everybody who's currently in there waiting for a panel decision should be allowed to say, right, I'm finished now, I want to jump across, because those are the people who are going to reject the offer the panel gives anyway. So why are we wasting their time? And I've said this, we're wasting public monies on the panel sitting.
A cynical view on that could be that they're trying to manage the flow of cases that come across to keep the numbers down.
Anything further, Mr. Madders?
I've got to say, I genuinely want to say this. I do think DBT want to be generous. This idea that somehow it's a plan. So I don't entirely agree with Neil, but I think it's just the panel that has been set up for HSS is set in its ways. I know there's been an attempt to get Sagari involved at that stage, Sagari Higginbottom, but that doesn't work. Just get this. Let's get into the appeals stage where we can get proper advice to clients and proper expert reports.
Just to try and get some balance, are there any redeeming features to the HSS? Are there clients who go away content with what's been offered there, or is it really simply this is just the hurdle that you've got to go through?
I would say that the clients who walk away from it are the ones who take the 75,000, but the ones who go to panel don't seem to be happy. So if someone's going to take the 75,000, well, that's all well and good. And when the minister invoked that scheme, it was an excellent idea, and it did get rid of the vast majority of the smaller cases. But what we're left with are the complicated cases, or those who just will not accept the small figures that the panel offers. So why waste their time and public money?
Okay, I'm just looking at the numbers that are reported by DBT on the HSS original deadline schemes. So settled cases in January were 2,090, settled cases in November were 2,130. So they'd settled the grand total of 40 cases over the course of last year. That's 6 days a case. On that basis, it's going to take them 6.5 years to clear the remaining 287 cases. That's August 2032. Is that your view about how slowly this process is working at the moment?
I'm not sure about that, Dace, but certainly if it continues at the current rate, it's multiple years, 2, 3, 4 years.
Right. Okay. Mr. Enright, anything to add to that timescale? Mr. O'Rourke, anything to... Would you share that?
I do know that I have heard that there are more panels, that the panel is sitting on more days, and so we may see that speed up. But I can't see it. It's going to take a long time, if not years, to resolve the panel decisions. And so my view is, let's just get on with it in the appeal scheme.
So the process at the moment is running so slowly, your judgment is it will still take a matter of years to clear the outstanding cases?
Correct.
Okay. Mr. Aldrich, do you want to just finish us up?
So the government agreed with Sir Wyn's recommendation to implement a redress scheme for close family members of sub-postmasters. It's a general question to all of you. In your view, how will this impact family members, and do you have any concerns around the proposed schemes? Kieran, do you want your hand shot up there?
Yeah, I've just shot up because I've got some statistics.
Okay, great, thanks.
So we have had 242 family members make inquiries. The government announcement was that there was would be a family scheme which would only compensate personal injury, and that would be where an individual had contemporaneous medical evidence, GP records, what it might be. Now, the reality is, I think that has moved on because there have been ongoing discussions with the Department for Business and Trade. They have engaged us, and the reality of someone whose husband was convicted taking her child to the GP while she was trying to save the family home from being repossessed, as the main breadwinner had left the house because he was an HMP Wandsworth, is unrealistic that there would be some records in there. So our analysis of our 242 inquiries that we've had from family members is that 99% of them have indicated they have some sort of psychiatric or psychological injury. 83% say they have a physical injury, such as nausea, etc., flare-ups of immune reactions. Only 30% went to a GP at the time. So a huge amount would be excluded if that was to remain the case, and I suggest it's not going to be. I think the government have moved from that. 82% suffered a stigma or reputational loss, and there was 92% it damaged their relationships, their familial relationships. Impact on education, housing and work was 65% of the family members were impacted by that. And in terms of the other important question the government needs to get right, and I do think it is difficult to either you make the scheme very large and very wide, and there could be a fear of overcompensating people, but the real danger is that you make it so narrow that you undercompensate the real victims, and that's a fine balance that government has to find the answer to. So in terms of who is a family member, because that's an important question, we have, of that cohort of 242, 56% are children, 29% are spouses, stroke partners, 7% are siblings, 5% are parents, ex-partners are 2%, and then we have 1% niece, nephew. My concern here is that in South Asian communities, you have a large family group, which is extended family, which became where the family members were involved in the family business of the post office. Yeah. And if we go down the road of excluding, say, brothers, siblings, 7%, then we're in real danger. My other concern is in relation to financial losses, pecuniary losses. We found that in our examination of our client cohort that, or those who would be wanting to make an application under this new scheme, that 49% had lent money to the postmaster to fund the shortfalls. 40% had borrowed money in order to lend money to the postmaster to fund shortfalls. And I don't think these schemes or the proposals that we've been in discussions with the government on are going to easily compensate that cohort. And I think that's wrong. For example, a parent who remortgaged the house to save their child from going to prison, the idea that they should just take that loss and not the public purse, there's something wrong in that as a sense
Anything
of
to add, Mr. Hutchell, on the definition of the family groups that
I have
should be
very
charged to redress?
similar experiences. I'm privileged enough to look after the lost chances, the children's group, Rebecca and Katie here today. I'm encouraged by DBT's approach on the new capture scheme, which is light touch and is producing offers very, very early. I think there's some lessons that have been learned. It's important that the cohort of claimants are properly captured so that the genuine victims are compensated. I think we need to be very, very careful that we don't continue re-traumatising people that are so hugely traumatised. Your next witness from Fujitsu is a gentleman who met Lost Chances in August 2024 to hear their story. It's one of the most traumatising meetings I've ever been to. Nine grown-up children that had to grow up too early, age 13, running a job to provide a family income. Another one working in news agents, delivering papers with their parents on the front pages as criminals.
Yeah.
You know, and this whole experience is deeply traumatising. So when they meet someone in August of 24 that gives them assurances that something's going to happen and nothing happens,
Yeah.
those are the things that we need to avoid and we need to take cognizance of.
Okay, well look, the clock is slightly against us, so thank you very much indeed for that comprehensive set of evidence. That's given us a great basis for the recommendations that we make in our follow-up report to this. This concludes this panel. Order, order. Order, order. Welcome to this third panel in today's hearings of the Business and Trade Committee as we pursue our inquiries into how do we secure justice for the sub-postmasters. Mr. Patterson, thank you very much indeed for returning to come before the committee once again. We first met almost 2 years ago, and 2 years ago you told the committee that Fujitsu has a moral obligation to contribute to the redress payments for sub-postmasters. The bill provided by the Chancellor is now 1.8 billion. We know that 1.4 billion has been paid out. How much of this will Fujitsu contribute to?
Chair, when we last spoke, I agreed with you actually on the moral contribution topic, and I have maintained that position for the last 2 years since I saw you. In terms of the quantum, the number, yet to be decided. We need to be informed by Sir Wynn's report. Even in the last 18 months of that report, new evidence, new information comes to light. And we want to see that report, and that was in my conversations also with the ministers about our commitment to redress. So we will make a commitment to it. The quantum we will decide when we get to the final report.
So I don't think we know whether Sir Wyn Williams is actually going to opine on what fraction of the bill should be paid by the government and the taxpayer and what fraction should be paid by anybody else. But what we do know is that Fujitsu played a part in this appalling miscarriage of justice because you said, in your words, we were involved from the very start, we did have bugs and errors in the system, and we did help the Post Office in their prosecutions of the sub-postmasters. So let me ask the question in a different way. In your accounts, in your conversations with Fujitsu headquarters in Japan, how much have you provisioned to pay into the redress pot?
This was the same question you asked me 2 years ago about where are we in putting a provision into our report and accounts, and the answer to that is we have not made a provision into our report and accounts. It would be inappropriate for us to do that yet. We have got a commitment. I have made that commitment every time for the last 2 years, and we will contribute to redress when we have opined, or when the Sir Wyn has opinioned on what that quantum should be.
You're a publicly listed company. Surely your shareholders would expect a provision which will be, if not 1.8 billion, then in the hundreds of millions of pounds. How come you've not provisioned to make that payment now?
Because we don't know the exact number of what that should be, Chair.
But
and
why
so
wouldn't you provision 1.8 billion?
Because that would be inappropriate for us to commit to a 1.8 billion.
Well, look, you said when we last met that you had a gut feel, that was your phrase, that staff in your organisation knew there were problems with the Horizon system before 2010. And we now know from your own statements to the Wynne-Williams inquiry and in the contract that was disclosed dating back to August 2006, that was 4 months before Lee Castleton's trial, Fujitsu and the Post Office not only knew that there were problems, you had a contract to deal with them under which Fujitsu would fix Horizon defects and bear liability for losses caused by system errors. We then had the testimony of Richard Roll, who said that Fujitsu employees had been accessing the Horizon system to fix problems. He dates that to his time working with Fujitsu, which was 2001 to 2004. And at that point, there were a reported 30 people working on the issue of wrong payments. So you must accept that there's now irrefutable evidence that Fujitsu knew about these system errors and were managing these system errors well before 2010.
The document I think you're referring to is a reconciliation service description that was disclosed in my second and fourth corporate statement. It was also reviewed by Justice Fraser in his GLO inquiry as well. I have always maintained, the company has always maintained since I've been sitting in this seat, that there were bugs and errors and there was remote access. In fact, in that document, I agree with you, section 17 talks about remote access. So there was no secret about whether there was or not remote access. The key to that document is how do you deal with the problems. Whether those problems were disclosed to the sub-postmasters in their defence, I do not know. And that was one of your other questions last time around disclosure. I don't know, but I'm certainly not going to deny there were bugs, there were errors. There continues to be. Horizon is a end-of-life product many, many years ago, and you'll also recall the last time I spoke to you, I did not want to renew any or extend any contracts with the Post Office.
But the point is, the new evidence that has come into the public domain and which is now widely circulated in the media confirms that it's not merely a case of having a gut feel that Fujitsu employees knew about remote access. We've now got irrefutable evidence that Fujitsu did know about remote access and the ability for Fujitsu employees to change balances remotely.
Chair, it's never been in doubt from the very start of this procurement back in 1999, and you'll see it in the evidence that's been given to Sir Wynne's inquiry, there were bugs, there were errors. There would always be in any project of this scale, particularly developed in 1990 to 2000. So there were always going to be those problems. The question is, what do you do about those problems? That document that we're both referring to is about how do you deal with those problems. We are not saying there were no problems. There were absolutely problems in the system, and I've been consistent in that position since I've given evidence both here and to Sir Wynne.
If you're then admitting a level of culpability of Fujitsu systems in creating this scandal, then you're accepting that there is a moral responsibility for Fujitsu to contribute to the redress bill, but you're telling us that there is zero provision, literally zero provision by Fujitsu for a financial contribution. That just seems an extraordinary bit of forward planning by Fujitsu.
Well, I don't agree on bad forward planning. We have been consistent in the message and in the commitment to redress.
You're saying that you definitely need to contribute some money, but you're provisioning literally zero in your accounts for that contribution. Please.
So I've answered the question the last time I was here, and I'll answer it again today. We have not made any provision, and we will not be making any provision until we've seen the report. But our commitment to, our commitment, and it has been discussed and been speculated, our commitment is 100%. We will make a contribution to redress to the government when we've seen the report. We've been very consistent in that. Whether we've accounted for it in our report and accounts or not is not material at this point. The commitment is there.
I want to just tell the committee, in the last annual reports that Fujitsu reported, what was the annual profits made by Fujitsu?
So FSL made £15 million last year.
And Fujitsu globally?
That number I don't have in the top of my head.
It's 1.2 to 1.3 billion pounds, depending on the exchange rate. That is about £3.5 million a day. Do you want to just tell us how much in revenue from the British taxpayer you've taken in contract extensions since the moratorium of May 2024?
So when I appeared here the last time and in my letters to the Cabinet Office, I made a commitment that we would not bid for new government business. And we have not bid for new government business. We have got a number of contractual obligations to departments here in the UK, which we are very, very serious about. They are also critical national infrastructure. Government has the right in all the contracts, not just with Fujitsu, with everybody else, to extend those contracts. The government has chosen to extend some of those contracts. The approximate number is about £500 million, which is the total contract value if they go to term.
That's over £1 million a day, basically, since May 2024. So we've got a global group making £3.5 million in profit a day. We've got Fujitsu here in the UK taking £1 million a day from British taxpayers, but there is zero provision for you to contribute to the redress bill of 1.8 billion.
You've heard my commitment, and that commitment's been consistent.
So when you came here 2 years ago, you told us that, in your words, we are an ethical company, quite different to the company in the early 2000s. But you've told us that the company is culpable in causing this scandal. You've told us there's 3.5 million in profits a day, 1 million in contracts from the British taxpayer a day, but zero commitment on a contribution towards the redress bill. You can see why we just can't believe the company has changed.
Well, what's in the accounts and what we provision are, I think, immaterial as to our commitment as a company. What we have done in the last 2 years is we have changed our management, in the last 4 years, we have changed our management team here in the UK. We've run an external organisation called Ethisphere to help us with culture and ethics. We've used that company to help guide us in both our policies, our procedures and our training, not PowerPoint, actual real work in trying to determine whether we are adhering to our own Fujitsu way, which again was one of your questions the last time we appeared. Those things are changed. The company in 1999 to 2005 or 2010 is a very different company today to that company years ago. Whether we've provisioned the sum of money or not, Chair, I do not think is important. What I do think is important, I really don't think it is. The commitment is there from us that we will contribute.
But Mr. Patterson, right now we don't know whether that is going to be 1 million or 1.8 billion. You're trying to present Fujitsu as a changed and ethical company. There doesn't appear to be a problem with cash flow. There doesn't appear to be a problem with profitability. There is definitely culpability. But your refusal to tell us how much Fujitsu will pay into a £1.8 billion bill for taxpayers leads people to the conclusion that, frankly, Fujitsu is behaving like a parasite on the British state without an obligation to step up to its obligations.
We're not a parasite, Chair. The government has got an option as to whether they wish to extend those contracts or not. If you wish us to walk away from those contracts, we'll walk away from those contracts. I think that would be detrimental to society. I think it would be detrimental to the UK government. The government and the Post Office have asked us to extend the Post Office contract. We don't want to do that. We're doing it because the government have asked us to do it. So we're not parasites at all. We've been in this country, trading in this country for 40 plus years. Our company is proud of our investments as a Japanese investor in the UK, the 5,000 people that we employ and the hundreds of subcontractors that we use in this country. We're a very serious organisation about what we do. However, we need to be informed by Sir Win. Even in the last 2 years since I last appeared with you, I didn't know about a capture system. I didn't know before the Horizon system was a capture system. I didn't know that there were victims of that. I didn't know there was legal advice in 2013 telling the Post Office what to do or not to do. That is why Sir Win's advice is really, really important to us and will inform the commitment I'm giving you again today and I've given to the committee before that we will contribute to redress.
And how much have ministers asked you for?
Excuse me?
How much have ministers asked you for?
No money, no number has ever been given to me by a minister.
And no minister has asked you to contribute or to begin provisioning for a particular share of your company's cash flows to pay into the redress bill?
My conversation with government ministers have covered 3 topics, and it's a regular conversation I have with DBT. First one is on where we are with restorative justice programme, which was a volume 1 of Sir Win's report, and where are we in dealing with that action. Second one, where are we on the post office and the transition from Fujitsu to their new supplier? And the third one, where are we on compensation or contribution to compensation? We have not agreed a number. Again, for exactly the same reason, we don't know the answer yet from Sir Win.
When do you expect that answer to come from Sir Win? When do you expect the answer to come from Sir Win?
I have no knowledge.
Mr. Maynard.
Yeah, thank you, Mr. Patterson, for being here today. Not a difficult position to be in. I take the point about Win Williams and deferring to that, and I think that's reasonable. I think the Chair's point about the scale of Fujitsu, I mean, it's £49 billion of market cap. This company can afford to pay a very substantial chunk of, and this whole problem would not have happened without Fujitsu's failures. That's obvious. There are many failures here, but Fujitsu's technology is the root cause of that. I would maybe, with the Chair's permission, ask you to send a message back to the Chairman Furuta and the CEO Tokita that we look to them personally to take responsibility. It's great having you here, thank you, but we are looking to them to take responsibility for what their company have done to all these people. And when they coming to that redress, we would like them to be here, please, to be in front of us, alongside you and the committee, to explain if they're not paying 1.8 billion in full, why not?
Thank you. I understand your question. The previous Secretary of State for Department of Business and Trade met Tokita-san in Tokyo several months ago. He made the same commitment I've just given to the Chair in terms of our contribution to redress and to await the outcome of Sir Win's inquiry. So that commitment was made in the room at that point in time. I can't speak to whether they would be in the room with us, of course, Mr. Maynard, but I can certainly commit to that commitment because I was in the room when the conversation was had. In terms of the core problem here and why this miscarriage of justice occurred, the reason why Sir Win has taken as long as he's taking to investigate is it's super complex. It was over 2 decades ago. Any system of any type, particularly one designed in the decades previous, will have had problems and errors and bugs and remote access. What was done, what was disclosed, what was given to sub-postmasters as evidence, I do not know. But what I do know is those problems were there.
Thank you. Let's get quickly to that settlement as quick as we can.
Okay, Mr. Cooper.
Thank you, Chairman. Just on that, the situation with the money, you talk about the ethics around it and you say that you're committed to paying something. Why not make an interim payment then? Why wouldn't you demonstrate your new ethical approach and make an interim payment? Are you waiting for Sir Win to give you a specific figure?
I believe if we started talking about an interim number, it would create a whole bunch of questions which would be unnecessary in a vacuum with regards to Sir Win. Secondly, the police are currently investigating 54 people. They've investigated 4 people under caution. All of those things are in play. For me to start talking about an interim payment would be inappropriate in that context. The company is not walking away from the UK. We are here. We've been here for 40 years. We intend to be here for the next. And our commitment to making that contribution is there. But an interim payment would be inappropriate in my view.
Thank you. And you touched on Sir Win's recommendation that you embark on a process of restorative justice with the victims. What steps have you taken to action that thus far?
So Sir Win published his Volume 1 report, I think, in the summer last year. He asked for a response from Fujitsu, DBT and the Post Office by October. Between all 3 parties, Mr. Cooper, we came very quickly to a conclusion that, frankly, we needed some experts on restorative justice. In my evidence to the inquiry, I did not understand personally restorative justice. I have been personally educated by the CEO of the Restorative Justice Council, who all three organisations have contracted with. That has produced a report which went into Sir Win. We are jointly funding an outreach programme to sub-postmasters, a listening service and a helpline service as well. At the end of this month, There will be a subsequent report from the Restorative Justice Council on what do we do after March, which is where our current engagement between all three parties finish. My expectations and my commitment, and I've made this also into Jim Simon, the CEO, is we expect this to be a 5-year engagement around restorative justice. We expect that, certainly from a Fujitsu perspective, to be focused on health and well-being and education. We think those would be the 2 areas where we can probably make the most impact.
Okay, so that process has begun.
It has indeed.
That 5-year is underway. We've heard evidence today that you met with the Lost Chances group who are here in the public gallery. Can you tell us what steps you are taking to support that group? And my understanding of that group is that they work with families affected by all of this. So what are you doing to support them?
So the education, I made a reference a moment ago to Restorative Justice Council. Some very clear advice from their 25 years of experience around this is ad hoc meetings with no structure are actually detrimental. And they have guided us and DBT and Post Office around ensuring that any interactions regarding restorative justice, which I think is what is appropriate for the Lost Chances families, is the right vehicle to use. So I'm expecting, and in fact I believe the Lost Chances have been in contact with the CEO of RJC around their engagement in that process. I think 150 sub-postmasters have engaged in the process and have asked for subsequent restorative justice meetings, and we are training Fujitsu people, DBT people and Post Office people to be able to engage appropriately in that process. RJC, though, are very clear these have to be managed appropriately. They cannot just be ad hoc meetings, they can be detrimental.
Your involvement with Lost Chances is through RGC rather than directly.
That will be well.
But you have had a meeting with Lost Chances previously, is that right?
I did meet Lost Chances, and I think Mr. Hudgels made a comment about that earlier. His description of it, I would agree with. It was a very difficult meeting for the families to talk to me about their experiences, which I think I've said before actually. As a citizen of this country, I found it very difficult to listen to, and the impact on them and their families as children. I had hoped we would have been able to do something around mental health and support for them. That turned out that we couldn't make that happen, but I'm now hopeful that the RJC process and the very direction from Sir Wynne will give us a vehicle to be able to engage with them through that process.
Thank you, Chair.
Thank you, Sarah Edwards.
Thank you, Chair. I just wanted to come back to what you were mentioning earlier about ethics and about the journey that you were saying that Fujitsu is currently going through in the UK, surrounding what has been probably what we might call a deficit of ethics in the scandal that obviously we're discussing. Now, of course, the accounting profession has a set of standards and principles and to be chartered, and you have to live up to those sort of governance requirements, but so too do engineers. And of course, there would have been a lot of engineers and information IT engineers working on this software. I think there was around 30 people that were working on this that were mentioned that could access things remotely. And I'm just interested in whether or not you have been engaging with institutions such as the UK Engineering Council, who have a directive from the Privy Council to look at these types of standards, and underneath them you have the British Computer Society, the Institute of Engineering and Technology, who have the delegated authority to look at the chartership. And with that, those who are chartered have to comply with the Statement of Ethical Principles. So I was just wondering, in this advice that you're receiving, or this ethical transition, what are you doing to look at whether or not both the executives that are making the decisions, but also the workforce in its entirety, and whether or not they hold chartership, are going to be adhering to those responsibilities?
Thank you. So the first thing I would say is what we were doing for the Post Office in the 1990s, 2000s, we do not do anymore. So the types of activity that are described particularly in the document that the chair was talking about, we do not do that type of work anymore. And in fact, for our current customers, where there is remote access, if I just go back to the essence of your question, the standards and the behaviours and the quality required are both documented in our contracts with customers, and as part of our training. To your point with Ethisphere, it wasn't just a PowerPoint activity. It was a reset. What are people doing day to day? Do they feel they can talk about, I feel uncomfortable about doing something, I've been asked to do something, more than just a whistleblower type of process? How do we make sure that opportunity for people, if they see something going on that makes them feel uncomfortable, can they engage in a way that protects them? We have worked that training through with Ethisphere. When we did it first, our scores were in the low 70s. Their international benchmark is 85. We were 83.5 when we did our last check, which was in October. I think your point, though, about the training with the Engineering Society, I hadn't thought about that one. Forgive me. I will take that one away and check on my side on that topic. Thank you.
Okay. Thank you. Mr. Madders.
Thank you. I'm just going to ask you about government contracts in a second, but I just wanted to come back to this question about provision for some payment by Fujitsu, because I think it's fair to say that we're all a little bit incredulous that there appears to be no provision made for this at all. What conversations have you had with your auditors about how this should be treated?
I talk to our auditors every quarter. I'll be talking to our auditors on Friday. Until there is a definitive quantum that we can quantify, we will not be making a provision in our report and accounts.
Does that mean that you've spoken to your auditors about this, or you haven't?
I meet my auditors every quarter. We talk about all the things you'd expect me to do in talking to my auditors about our report and accounts and our general business, and I have talked specifically about this topic.
And they've advised that it's not necessary to make a provision in the accounts?
Correct.
Okay, that's fine. So I'll just move on then to the question of new contracts, because you've made statements about not bidding for new government contracts. I think it's probably helpful just to go through the detail of that, because I would suggest it's not quite as clear-cut as some of the statements that have been made. In particular, I'm looking at the letter that Fujitsu sent to the Cabinet Office on the 6th of February 2024, which sets out the criteria you apply. So there's sort of effectively three sort of caveats to this not bidding for new contracts, where there's an extension of existing contracts for Fujitsu goods and services. I think we'll leave that one there for now for the sake of time. But you also intend to, it says here, submit bids in respect of re-procurement exercises, or what I would describe as new contracts, by existing government customers for similar goods and services where Fujitsu is the incumbent. So why is that not considered new government business?
Because it wasn't considered new government business by me when I wrote that letter. And I think the only example, which example would you use that we procured?
Well, if it's a new contract issued by government, is that not a new? Because you've got no guarantees that you would get the contract, would you? So that would be new business, surely.
So I determined back in January that wouldn't be the clause. I was very clear about it, and I was clear to the chair, and I've been clear in my letter. If the example you're using is the TSS contract, which is the trader support contract in Northern Ireland, which was procured courtesy of the Brexit process in 2019, government came to tender for that service. We built that service with our consortium on time, on budget, and have delivered it for 5 years. Government came back out to re-procure that, exactly to the point you're making, Mr. Manners. We decided to bid for that. We failed. Government have chosen a third-party company to do it, and our contract will end in November this year.
Have there been any circumstances when contracts have come up for re-tendering within this description where you've decided not to bid?
I would not. We have not bid for 46 tenders that were in the market from government. I would need to check whether any of the extensions we've done are in that. I don't know off the top of my head.
So within that 46, probably some of them would come within this third category of where there's a requirement for new goods and services not currently provided by Fujitsu with its existing customers. Fujitsu would very carefully assess the existing customs requirements and need for Fujitsu's skills and capabilities. So you're effectively judging yourself whether you should bid for new work there, aren't you?
So first of all, we've not bid for anything in that category, just to be clear. The rationale for it when I wrote the letter was we do work for the Ministry of Defence, both here in the UK and internationally, where we have a particular set of skills and capabilities and security clearance. That was the reason for that particular third bullet point.
Okay, but in terms of completely new business, you're confident. But do you know the approximate value of the sort of re-procurement exercises that you've
not the re-procurement, the extensions is to my answer to the chair a moment ago. I think it is £500 million there or thereabouts, yeah.
Okay. And given that you have already indicated you wish to make a contribution towards the costs of this, has there been any discussion about payment terms being altered in any way as a result, to take account of, an advance payment, for example?
No, not at all. Not at all. No, we will. You use the word we may. I'm being very clear. We will contribute, and there won't be any of those things that you just alluded to. We'll make a contribution, and that will be that.
Okay, thank you.
Okay, thank you. Just a couple of questions to round out. So, when you bid for government contracts, you've been asked to demonstrate some contingent liability insurance. To what extent do you think Fujitsu's liability insurance will cover off the redress payment that you may have to make in due course?
Don't understand the question, Chair. Forgive me.
Well, very often when you're asked to procure for public contracts, you've got to demonstrate some kind of insurance for the service that you're providing in case, for example, you make errors that cost the customer money.
Mm-hmm.
You will have insurance in place to underpin many of the public contracts that you've bid for.
Mm-hmm.
When you make that redress payment to the taxpayer, how much of that redress payment do you expect to be able to claim back from your insurance?
So I'm not sure I'm going to be able to answer your question entirely. So in our current contracts that we have with government, in some of those contracts there is a parental company guarantee, a PCG that is a self-insured process from our parent either in Europe or globally. I wouldn't be able to comment in detail on our insurance cover. I would need to check that, Chair, and I can, like I did the last time, I'll drop you a note on that.
Thank you. And then on lost chances, do you think at the moment that you are contributing the right level of resource, either financial or anything else, to the lost chances group?
So as my answer earlier, our focus is, as directed by Sir Win, is on the restorative justice process, which is, and I think government are engaging with the Postal Museum on one part of legacy. I've made the comment a moment ago, we expect our contribution to be for possibly up to 5 years, and that will be in the health and well-being area and education area. The families, and as I mentioned, should be coming through the restorative justice process rather than direct conversation with us. We will be focusing all of our attention on restorative justice.
But you're satisfied that Fujitsu is making the right level of contribution to that process?
So everything that RJC have asked us for on our side of the table, we have committed to do. I've made the commitment both in writing and to Sir Win that we'll also continue that for the next 5 years. The next part of their report is at the end of this month, which will tell us what we're going to be doing afterwards.
Okay,
so I don't expect any issues, Chair, with our commitment. We are fully committed to it.
Okay, thank you. Well, it feels to us on the committee that Parliament has done its bit, overturning convictions. The taxpayer has done their bit, contributing 1.8 billion to the redress scheme. It feels to us that we're still waiting for Fujitsu to do its bit. So we look forward to continuing this dialogue with you as Sir Win Williams finalises his report and we finalise our recommendations. But for now, that concludes this panel, with our thanks to you for coming before us to give evidence. Order, order.